In order for an invention to be patentable, it must fall within the definition of a patentable invention under Section 18(1) of the Patents Act. This section provides that an invention is a patentable invention if it is a manner of manufacture within the meaning of Section 6 of the Statute of Monopolies. Australia has a very broad approach of determining patentability and the types of subject matter that fall within manner of manufacture and patentable inventions. The basic position is that an invention will fall within patentable subject matter if it is either a product or process that is vendible, so it produces some sort of commercial economic benefit, and if it is of a useful art. This approach derived from the 1959 landmark Australian case of National Research Development Corporation and Commissioner of Patents, more commonly known as the NRDC case. The broad approach in this case has been followed throughout Australian courts and has resulted in a number of inventions being classed as patentable subject matter. These inventions include computer software, business methods, and human gene sequences. There have been many instances when the courts have found computer software to be patentable subject matter, particularly in the case of International Business Machines Corporation and Commissioner of Patents. It was specifically held that computer programs will be a matter of manufacture, as it becomes a product when the inventor goes beyond using ordinary formulas to create something new and of use to the public. So when the program becomes transformed from a mere mathematical algorithm into something that people can actually use, and it is commercially viable, then it becomes a matter of manufacture and patentable subject matter for the purposes of Section 18. In the NRDC case, it was reinforced that mere theories and ideas can't be classed as patentable subject matter. In cases concerning business methods, this notion, along with the view that a business method is not a product, has been a matter of much debate. In the 2006 Federal Court case of Grant and Commissioner of Patents, the battle of whether or not business methods could be patentable inventions reached its peak. It was concluded that in order for a business method to be a patentable invention, it must have an element of physicality, being that the business method produces a direct effect of some sort and a transformation of the information into something, rather than just being an abstract idea. In regards to gene patents, Australian courts have had the opposite approach to America and Europe and have held that isolated gene sequences actually can be classed as patentable subject matter. To reach their conclusions on gene patents in Australia, courts have followed the principles in the NRDC case. Particularly in the case of Darcy and Myriad Genetics, the NRDC reasoning was used to find that an isolated gene sequence can be a product and a manner of manufacture, as an innovative process was created to isolate the gene sequence, and then once it was isolated, the sequence became something exceptionally different, allowing researchers to discover new properties and functions of the gene. Therefore, the Federal Court of Appeal held that as it stands in Australia, isolated gene sequences are patentable subject matter under Section 18 of the Patents Act. Biotechnology and medical treatments have also been held to be patentable inventions under Section 18 throughout various Australian cases, the reasoning being that there is some sort of human intervention that creates a new product and is of commercial use.